On behalf of Columbia Law School's National Security Law program, I'm delighted to welcome back Professor Bobby Chesney. He's the James Baker Chair at the University of Texas School of Law, where he also directs the Strauss Center for International Security and Law. Our topic today is the Foreign Intelligence Surveillance Act, or FISA. A law very much in the news these days, surrounded by all kinds of controversy. We're going to do two webinar sessions today. The first one is going to cover the basics of FISA. Why did Congress enact it? What does the law do? How does it work? What are some of the major criticisms and answers to those criticisms? And then in our second session, we'll talk about some of the important updates, especially post 9/11 amendments to the law or the way in which it operates. So with that, I'll turn it over to Bobby.
So what I'd like to do to introduce this topic to you in a way that will help it avoid well, let's face it, it can be kind of dry if you're not careful with how you present it. And so I've come up with a series of opening hypothetical scenarios, and we're going to use these three hypothetical scenarios involving three possible targets of FISA surveillance to help us walk through a series of discussions about the background and origins and the functioning and the issues with what I think of as the bread and butter part of FISA. We're going to call this FISA Title I, as you see there on the title slide. That just means, Title I in this context just means that this is the original part of FISA that's focused on specific individual targets where the government wants to conduct electronic surveillance, wiretapping, if you will, wiretapping or bugging, as we shall see. So without further ado, let's meet our hypothetical scenario individuals. First here we have Igor Golobski. Now that's actually, this one's real. He's actually the Russian consul in New York City. He's there at the Russian Consulate General, which is on East 91st Street. And you see there in the image, I'm not going to add a lot to the fact pattern there. The idea here is sometimes you have figures of foreign intelligence interest who are that not because of some specific thing you suspect they may be up to, but because of their status. He's the Russian consul in New York. Contrast him with John Doe. John Doe in this hypothetical scenario is an American citizen. He's a chef. He's down the East Village. He's Muslim. He's a fierce critic of the US government's overseas military activities. And a confidential informant in this hypothetical, a confidential informant has alleged to New York's Counterterrorism Bureau at NYPD that he knows John, has seen him watching Islamic State videos, has talked with John about this, and that John has expressed passionate support for the Islamic State, and then eventually claimed that, in fact, he's in touch with Islamic State representatives in Syria, and has been talking with them about how, in some fashion, he might, quote, bring the fight to New York City. So NYPD's counterterrorism folks talk to the FBI through the Joint Terrorism Task Force, and now John Doe is a person of very serious interest. Third, we've got Samantha Smith, a hypothetical American citizen who is a senior vice president at a financial institution right there in Manhattan. She has a close connection, as it happens, to a major party presidential candidate, is serving as an informal key policy advisor to that candidate, and is widely speculated to be a leading candidate to become the Treasury Secretary next year, depending on how the election goes. Samantha Smith has extensive business dealings in Pakistan. She's there frequently. She meets with government officials there. She meets with others there. She receives hefty honoraria for giving talks at gala dinners there. Recently, a well-placed source in Pakistan has told his CIA case officer that there's an effort underway involving Pakistan's Inter-Services Intelligence Agency, ISI, to recruit Smith as an asset. Now, there may or may not be criminal activity in these three fact patterns. There's definitely, perhaps in some of them, there's definitely in all three fact patterns something of interest from a foreign intelligence perspective. That is, all three of them are plausible candidates to be foreign intelligence targets. And let me emphasize something right here at the outset. By saying that they are foreign intelligence topics or targets of interest, what I mean is that the information about them that is of foreign intelligence interest, it doesn't mean that they themselves are necessarily overseas at the time. They may all be, and indeed for our purposes will be, entirely within the domestic United States, but the interest the government has in them is of a foreign intelligence variety because of the nature of the information itself. So what I'm suggesting here is to avoid the temptation to assume that when you hear domestic intelligence or foreign intelligence, that is telling you something about where the target is. Where the target is not the determining factor. Avoid that trick. It's the nature of the information itself that decides whether we're going to call it domestic intel or foreign intel. Okay, moving along now. We have foreign intelligence interest, and therefore these two characters who are going to stand in here for the FBI for us, and if you watch the Americans TV show, you recognize them, or if you used to watch the Waltons or the Truman Show, you might recognize them. The FBI, when it comes to foreign intelligence activity where the information to be gathered is within the United States, then FBI is lead agency. So this is an FBI fact pattern we're developing here. These two would like to know a lot of things about our three targets. Among other things, though, they'd really like to know what kind of communications are these people taking part in? What is being said in their phone calls and their emails and in their text messages and communications on other platforms? And the issue before us is whether and how the law in America might allow them to surveil or to engage in what we will call, for our purposes, electronic surveillance of those communications. Now, let me pause here to note, if this was an ordinary criminal law investigation, which of course would also involve the FBI, because that's our lead federal law enforcement agency, in addition to being our domestically based foreign intelligence agency. If it was a criminal law investigation and the FBI agents wanted to surveil communications, engage in wiretapping, several things are clear. First of all, it'd be perfectly clear today that the Fourth Amendment applies, and thus that some form of warrant is required. It would also be clear under a statute from 1968 known as Title III. It'd be clear that Title III would provide the framework whereby the FBI would go to court, make an application, and if they have sufficient evidence to show by the probable cause standard that a crime has been or is about to be committed, and that surveilling these particular platforms would probably, by probable cause, lead to evidence of said crimes, that they could get a Title III warrant and they could conduct the surveillance. And it would also be clear that upon the expiration of the warrant, eventually the targets of that surveillance would be notified after the fact that the surveillance occurred. Even if they weren't prosecuted, they would eventually get notice. Now, we might pause there. Let me catch up to my slides. What we want to know is whether electronic surveillance alternatively could be pursued not under the criminal law model of Title III, but under the foreign intelligence legal framework known as the Foreign Intelligence Surveillance Act, Title I.
And Bobby, just to jump in, sorry, can you, as you go through this, could you talk a bit about why the government couldn't just rely on a so-called Title III criminal justice wiretap? Why do we need a foreign intelligence alternative at all?
Right. So as I just emphasized, they probably could if we assume that they've got enough evidence to back up these suspicions as I described them. In some of those cases, the chef with the suspicion of involvement in terrorism, and maybe the executive with the suspicion that she might be being recruited by the Pakistanis. Certainly the chef, you could assume that it'd be probably possible to go get that Title III criminal law warrant. But as I emphasized, he'd get notification eventually. And depending on what the smart play is with the chef, maybe that's not a wise way to go. In fact, maybe that's unwise, because it could be that what's in the interest of the government is to watch and monitor him over time. But never mind that. Let's look at the other two. The executive, it's not clear yet that she's committed any crimes. In fact, it's far from obvious from the hypothetical facts I gave a moment ago that she could be shown to be involved in crime. If anything, she may be a victim at this stage. We need more facts before we could show that a crime's been committed in her case. And then as to the consul, I've suggested nothing of crime, right? There's no basis for getting a Title III warrant to surveil his communication, so Title III won't help at all. So some combination of these factors, the inability to actually get a criminal law Title III warrant, the desire to ensure that there will not be notification that the government has become interested in the person to the point of surveilling their communication, or the possibility that, that there is no crime at all. Any of these possibilities could lead you to prefer to have, if there is a mechanism, surveillance conducted under a non-law enforcement mechanism. FISA Title I is that mechanism for our purposes, as we're going to see. And so those are a multitude of reasons why you would like to have this mechanism available in some cases. The question, that doesn't mean anything goes, and we want to just say, yes, the government can go around the country surveilling people within the United States however they feel like it, as long as it's for foreign intelligence purposes. You want to have this very intrusive capability carefully limited and constrained, but also enabled. And so what we want to figure out in today's session here is, how has it been constrained? How has FISA Title I been constructed to enable this activity while keeping it within reasonable bounds? And what sort of issues arise as it currently stands? So here's our roadmap for how that's gonna work out for us in this lecture. Basically, this boils down to how things used to work before there were FISA. Why did FISA come about? What are the mechanics of it? And what are the issues that arise along the way? And we'll keep staying with the chef, the executive, and the consul as our hypotheticals to help us keep track of how it works without getting too bored along the way. And in case you are bored along the way, starting you'll perk up at the end, I hope, when we get to Inspector General Horowitz's report, which is a dramatic recent intervention into both our understanding of how all of this really works in practice and what some of the issues with it might be. Okay, so first, how things used to work before there was a FISA. If we go back prior to 1978, and agents are wanting to wiretap to listen into phone calls or put an electronic listening device into a room, a so-called bug, could they just do it without a court authorization when there was no FISA? Well, the answer kind of depends on how far back you go prior to the creation of FISA in the 1970s. For better or worse, through most of that period in the 20th century, the answer was actually yes, you could do it. The government did do it in cases involving national security intelligence interest. The key to understanding how it was that this took place without any kind of court involvement begins with the fact that until 1967, the Supreme Court took the view that most wiretapping of phone calls didn't even implicate the Fourth Amendment, because the wiretapping could be effectuated without going into someone's home or private office. That is, you could go down to the switches at the phone company or out on the wire out on the streets. You could effectuate it there, and so there was no physical intrusion. And as amazing as this may sound to people who only know the more modern approach to the Fourth Amendment, for decades that meant no Fourth Amendment warrant requirement. And if there was no warrant requirement, of course, that doesn't mean that Congress couldn't step in and impose a warrant requirement of some sorts. During most of the 20th century, the way Congress handled this was not to impose a warrant requirement, but to say that wiretapping is illegal. And as far as the government was concerned, the way that this had bite was that you could not, if you did wiretap, you could not divulge to another what you'd heard, meaning that you couldn't use the evidence in court. But if you're not a criminal investigator, if instead you're a foreign intelligence investigator, not being able to use the evidence in court was not necessarily a problem. So to sum up, the Fourth Amendment for decades was thought not to require a warrant. And the big statute that governed in this space, well, it was a problem for would-be criminal law enforcement wiretappers. It was no obstacle at all for would-be foreign intelligence collectors who, you know, maybe they would care a bit about whether there could be prosecution, but mainly they'd be in the interest of gathering information that analysts could use to better inform the decision-making of the US government. Now, in 1967, it all begins to change because the Supreme Court intervenes that year, holds that, in fact, the extent of the Fourth Amendment's protections goes wherever one has a reasonable expectation of privacy, and that phone calls and communications that are taking place in private but over phone lines, they're protected no matter where the wiretapping is effectuated, well, at least in the criminal investigative context. So the big 1967 case was specifically a criminal law enforcement case, and the court even included a footnote saying that they weren't offering any opinion about whether the same analysis would hold true if it was an intelligence or national security setting, not just criminal investigation. Well, the next year, Congress created that Title III mechanism I described earlier, allowing criminal investigators to go to court through the Title III system, get a warrant. And now, not on one hand, yes, they were constrained because now they had to get a warrant. But what mattered was now they could take the results if they did get the warrant, and they could go into court with them. What about foreign intelligence investigations? They maybe had a warrant requirement under the Fourth Amendment, but there was no Title III for them to go get one. So they just kept doing it, at least in some cases. In 1974, the Supreme Court took a shot at answering the question this presented. It was a case involving a purely domestic intelligence scenario, albeit one involving national security. A domestic anti-war group in Michigan had put a bomb outside a CIA-owned office. And it turned out when those people were prosecuted that the government had been warrantlessly wiretapping them in the name of security, not law enforcement. Supreme Court said that there were no foreign intelligence elements in that fact pattern. It was a purely domestic intelligence fact pattern, and that the Fourth Amendment required a warrant. And that Congress, if it wanted to, could and should create a Title III style statutory warrant system, but one that wouldn't turn on probable cause to believe a crime was committed, but rather probable cause to believe that there were domestic national security interests in play. And Congress never filled that gap. They never
Bobby,
passed
can you talk about why Congress didn't? Because there's an example where the Supreme Court is, it seems, practically inviting Congress to create some sort of purely domestic intelligence warrant system, or warrant light, perhaps, for purely domestic intelligence, and Congress doesn't bite.
Yeah, you know, and it's funny because other countries, plenty of other countries that have strong rule of law, free and open societies, do have purely domestic intelligence regimes. So the court invited it. Other countries do sometimes do it. We didn't. And it's because in the mid-1970s, really few things were in worse odor than the idea of domestic intelligence. It had become practically synonymous with political suppression, of dirty tricks. It was bound up in ideas of what Hoover's FBI sometimes had been up to in the past, which had just then come to light, the ongoing train of revelations in the newspapers and in congressional investigations in the 70s. And it was easily demonized as sort of Gestapo-like tactics, right? And it sounded un-American to have a domestic security state that wasn't law enforcement and wasn't about foreign intelligence collection. It felt un-American, to sum up. And there was never any appetite in Congress in the 1970s, and really hasn't been since then, to try to close that gap and to take the court up on its invitation to create a warrant system for that type of scenario. Again, we're talking about intelligence, but not foreign intelligence, purely domestic threats. It mattered too that almost, not all, but most scenarios you can think of under the domestic threat heading, given the expansion of federal criminal law over time, there were few scenarios you could come up with where you couldn't just proceed in the criminal investigative mode if you really had to. So it wasn't like the act of leaving this field unplowed meant that no investigations were happening. What it meant was that all the investigative pressure was pushed into the criminal law setting. And so FBI intelligence investigations that could have taken place under the domestic intelligence rubric, they had to proceed simply as criminal investigations, and Title III enabled that. So there you are at mid-70s. Criminal investigations now can include wiretapping. Domestic intelligence of the pure domestic variety is just dead. And foreign intelligence within the United States remains an open question. And for any reasonable observer, an objective observer in the mid to late 70s, who would like there to continue to be a foreign intelligence wiretapping option that doesn't involve having to just use the criminal tools for all the reasons I said earlier, might think that you have a choice. We could continue on the path we'd been on with warrantless surveillance, knowing that one day the court might step in and issue a third decision, this time closing the loop with the other ones by imposing a warrant requirement. and that there would be legitimacy issues and a whiff of something inappropriate since there'd be no statutory blessing for it. Or you could dive in and sort of take that earlier court invitation to create a statute and just go ahead and jump right to that for foreign intelligence. Create a statutory warrant system. And that's exactly what happened in 1978. So after all these aforementioned revelations, and I'm flipping through some slides that remind us of how this all went, famous news stories and other developments, the court is brought into the foreign intelligence game in this one specific and limited way by statute, 1978, the Foreign Intelligence Surveillance Act. To be clear, and I can't underscore this enough, no one at the time thought that what was happening, or what that should be happening, was that all the activities of the NSA and the CIA taking place outside the United States, trying to capture Soviet military traffic, trying to understand Deng Xiaoping's leadership intentions, trying to understand what's happening in Warsaw Pact countries. No one thought that the Foreign Intelligence Surveillance Act legislation was touching that activity. No one was arguing that it's time to bring the courts into a supervisory mode over all that, what we might call kind of classic foreign intelligence collection activity. And no one thought that what this was a green light to do purely domestic intelligence gathering. The idea was that there are legitimate foreign intelligence targets, sometimes in US territory. Sometimes it's foreign individuals, sometimes it's American citizens, but they're real and serious foreign intelligence interests in the United States. There's plainly a way to look at that where it involved Fourth Amendment, privacy type, American privacy interest. And the way to put everything on a stable equilibrium and a firm footing going forward would be to create a statutory warrant system tailored to that scenario, not requiring the government to prove crime had occurred, but trying to prove that people were agents of foreign powers. And so that's what the Foreign Intelligence Surveillance Act of 1978 set about to do. It called for a rotating cast of regular federal district judges to moonlight by appointment by the Chief Justice of the United States, also being judges of the Foreign Intelligence Surveillance Court, or the FISC. Simply put, you've got regular federal judges who have all their regular duties, but for a term of years, the Chief Justice would single out some of them, spread around the country, the different circuits, and have them also serve in this moonlighting role where they would be the judges to approve or disapprove applications for surveillance orders, for electronic surveillance orders in the FISA system. So their singular job at the time, it's expanded over time, but their singular job was deciding whether to authorize electronic surveillance or bugging using a process that was very familiar to anyone who knows how regular warrant applications, even non-surveillance warrant applications would work. The government would show up in court, and only the government. It would be ex parte and in camera. That is, the party to be surveilled does not get notification, because that would rather defeat the purpose of the surveillance. And the public's not invited in to observe either. It'd be an ex parte in camera showing where the government representative would present via affidavit a summary alleging facts that, if credited, ostensibly would show probable cause to believe that the statutory standard was met. In the criminal context, the probable cause standard is whether crime is occurring or has occurred. Here, the idea is instead to show that the target is a foreign power or an agent of a foreign power, and that surveillance of a particular platform, they call them facilities, but think phone numbers or later email addresses. The surveillance of the facility would yield foreign intelligence. And so let's tease this out more concretely by looking back to our three hypotheticals: the executive, the chef, the consul, and let's think about whether we can get a FISA order under Title I, the original FISA system, to surveil the communications of each of these three individuals. Where do we start? Well, we actually don't start with FISA at all. We're going to start instead with something called the Domestic Investigations and Operations Guide, the DIOG, D-I-O-G. The DIOG is the FBI's implementation manual, capturing all the FBI rules and larger Justice Department Attorney General guidelines that define whether and how the FBI can take certain investigative steps, what sort of predicates are required. And there's an important, the reason I'm dwelling on this is there's an important condition here that has to be satisfied before the FBI can even think in terms of getting a FISA to surveil somebody's communications. Simply put, there must be a so-called full investigation underway. Not a preliminary investigation or an assessment, but a full-blown investigation. The way you want to think about this is there are stages of seriousness of the FBI's explorations of a given person or topic, and a certain set of highly intrusive investigative methods, of which electronic surveillance is at the top of the heap, or it's right there at the top, are only available once you've progressed to a certain stage. So what does it take to open a full investigation? There are three scenarios, and we'll just run through this really quickly. The first and most obvious one would be that there's a federal crime afoot. But alternatively, even if it's not a crime, there can be threats to national security. So that's a second category. And that's a form, at least it can be a form of foreign intelligence. It can be a form of domestic intelligence too, although we don't do that, as I emphasized previously. Thirdly, there's so-called positive foreign intelligence. That is, it's not necessarily a threat scenario, but it's still a foreign intelligence interest. So this could be understanding, any number of things. Positions of a foreign government on trade negotiations would be a good innocuous example. It's not a threat, it's not a national security threat, but it's real foreign intelligence interest. And insofar as the FBI is in lead agency mode because you're inside the United States, then you need one of these three scenarios to be properly implicated before you can have a full investigation. The dialogue says that for a criminal-based investigation or a national security threat investigation, there needs to be articulable factual basis, not just a hunch, but an articulable factual basis to believe that crime or that threat exists. If it's positive foreign intelligence, that's not quite the standard. The standard has the ordinary process whereby the federal government tells all of its intelligence agencies what it wants them to collect about, what topics are the topics the customers want to know about. You have to have one of those collection requirements that's pertinent. In that case, you can do a full investigation for positive foreign intelligence purposes. So those are the basics of how this works. Let's apply it to our three friends. Looking first to, well, actually, let's skip the executive. Let's start with the consul. The consul is such an easy case. The consul, of course, is a ripe source of positive foreign intelligence. You can bet at any given time that there are any number of collection requirements that the FBI has been given that have to do with understanding the intentions and activities of the Russian government. And the consulate general is a great place to look for that. It's not the only one, but that's an easy case. You don't need a crime. You don't even need a national security threat. He's the personification of positive foreign intelligence interest. Now, turning to our chef, the chef is the one that we think we have reason to believe is involved with the Islamic State. So this is clearly an international terrorism scenario. It's potentially a crime. We have articulable factual basis in the form of the representations from an informant about what the chef has been up to and what he's been saying he's interested in doing. So we have a basis for a full investigation of a criminal nature. I would say we equally have a full investigation predicate for a national security threat, given that we're talking about terrorism. And indeed, we can probably safely assume that there's a standing collection requirement relating to the Islamic State and international jihadi extremist terrorism, that sort of thing, to where there's any number of pathways whereby you could have a full investigation and consider going to the FISC to get a surveillance order as to the chef. The executive is interesting and a little bit tricky. We can imagine, well, let's start with the complication that jumps out at us right away. Until we get more facts, the executive is arguably more victim than target. The executive, we're talking about information that suggests that the ISI in Pakistan is hoping to turn her into an asset, whether by persuasion or compromise or otherwise. But let's change our fact pattern to make this a little simpler. Let's imagine that we get a further statement from an informant, or maybe a signals intercept from some other source that gives a concrete reason to believe that she actually has crossed that line and may be acting on behalf of the Pakistani government and on behalf of Pakistani interests. We still have a further complication with her before we proceed to just willy-nilly open a full investigation. Remember the hypothetical, imagine that she's closely connected to a presidential candidate and has been touted in the media as a future Treasury Secretary. This is a good example of what we call a sensitive investigative matter, a SIM. A sensitive investigative matter, that's FBI speak for a potential target that raises rather obvious larger consequences. Sitting government officials, political candidates, reporters, major religious figures. There's all sorts of possibilities where the target's special nature or context raises bigger picture issues. That doesn't mean they get a free pass. All it means is that the decision to pursue investigative means in relation to that person, that needs to be elevated within the FBI, within the DOJ, to the visible layer of senior officials, and that certain steps aren't taken unless those senior officials are aware of the situation and have authorized those further steps. So special notifications and approvals are required. But let's assume that those have been obtained in this case. We now have the dialogue hypothetically satisfied here. We've got the conditions to move forward. Let's talk about what it takes to actually move forward under FISA Title I. First things first, somebody's got to prepare an application, and the agent in the field office who's running the investigation, that person's basically going to have the task of doing this. What must go into the application? You know, normally you don't get to see these, but thanks to all the controversy and investigation surrounding the actual investigation in FISA orders targeting Carter Page, there's been a lot of declassification and release to the public of some documents you don't normally see. So you can actually look at a verified application right here. It's the front page. It's a court filing. Again, the original version, that's ex parte in camera. No one on the outside knows this is happening. That's rather the whole point. So you're the agent investigating either the chef, the consul, the executive. What you do when you sit down to fill out the application is you're opening up a template, because this has been done before. There's a standard way to write these things. There are a whole lot of formalities and formal representations and certifications that go into them. You'll just kind of adapt that and copy them over for this purpose. But the part that you're going to have to write fresh, and it's the heart of the matter, is the description of the facts that your investigation has unearthed so far, that you believe in, that the allegations that you believe are supported by evidence pertaining to the ultimate question the FIS is going to have to decide. Is this person an agent of a foreign power or not?
Bobby, could you talk about how this procedure that you're walking us through compares to the ordinary warrant? We labeled it before the Title III warrant. How does the FISA application, how is it similar or different from the process of applying for a criminal justice wiretapping warrant?
So in so many ways, it's the same process. It's certainly modeled on the ordinary warrant process. In both cases, as I emphasized earlier, the public is not privy to what's happening at the time. In both cases, the target of the eventual search is not notified, is not represented in court. There's not even a guardian ad litem or other sort of stand-in interest representing that person. It's ex parte, taking place behind closed doors with just the government making arguments to the judge. In both cases, the standard of evidence or the burden of proof is on the government. The standard is probable cause. It's not preponderance of the evidence. It's all relatively forgiving. But there's a dramatic difference on the back end most of the time. In the criminal context, eventually, even if there's no prosecution, if not right away, then eventually the expectation very much is that the target of the search, the person whose place or property or communications were surveilled, they will get notification. They'll find out what happened. And in most cases, in the search warrant context in criminal investigations, there will be a prosecution. And the point of the search, of course, was originally to get evidence that can be used in the prosecution. And at that point, there can be a suppression motion, litigation over whether, sort of post hoc relitigation over whether it was proper to grant that motion initially. And if the answer is no, actually, the better view is that it shouldn't have been granted, then the evidence can be suppressed. That normally doesn't happen in the FISA context. There's no post hoc notification. That's a major premise of even having the system is there's no default assumption that the target will ever be notified. Because the idea is the government may or may not ever want the target to know that they became a person of foreign intelligence interest. And indeed, that the whole game would be up if they did. Secondly, and critically, it's relatively rare, as we'll see later on, not impossible, but very rare relative to the number of FISA applications to actually then later on have a court proceeding where the target is being prosecuted and the FISA evidence being used. So it's very rare for there to be suppression motions. That's a chink in the armor constitutionally or as a matter of legal policy from the privacy perspective. It means that there isn't most of the time going to be at least an after the fact adversarial proceeding. And that makes it look a little less comfortable for us, doesn't it, from a privacy perspective? But overall, the process looks pretty similar otherwise. Now, let me unpack a little bit further the things that the government's really got to show here. It's all about showing that the target, not that they committed a crime, but that there's a foreign power or an agent of a foreign power. And that raises really complex questions as to how do we define those terms. That may sound clear enough at first blush, but the statute defines them. And I regret I'm going to take us into the weeds a little bit here, but we need to do it. And then we'll make it seem more real by taking our three fact patterns, the chef, the executive, and the consul, and we'll see how they fit with these definitions. And so you can be thinking about them as we go through them initially here. First, the statute defines foreign power. And the heart of foreign power, of course, would be foreign governments. The Russian government is a paradigm. Any foreign government is a paradigm. And that includes any entities, like maybe commercial entities that are directed and controlled, that are owned and operated by the government entities themselves. What about private foreign entities? Not everything outside the United States is a public governmental entity. What about all the private foreign entities? They can count, and I'm paraphrasing here, but it boils down to this. They count if it's a private political organization, so a foreign political organization, like a political party or political organization of some other kind, that counts. An international terrorist group would count. And an organization that engages in WMD, weapon of mass destruction proliferation, those can all count. And what it means to be a foreign power, to count for this purpose, means both that the organization's own actual communication facilities, like, so let's say there's a phone number in a building that belongs to one of these organizations and it's used by the organization as such. That could be an object of FISA's collection. And then you've got individual people. If you have people who count as agents of one of these foreign powers, you can surveil them and their communication platforms too. So we need to dig into who counts as an individualized agent of a foreign power. This is where it really gets complicated because there's a set of triggers or sufficient conditions if the target's a US person, and this is a relatively narrow set. Then there's those same conditions plus others if we're talking about non-US persons. And by the way, a US person for purposes of this analysis means a citizen or a lawful permanent resident. Everyone else is a non-US person. I'll use the abbreviation USP sometimes in my slides here, and non-USP. Just remember, USP means citizen or green card holder. Non-USP means everybody else. So to establish and get a FISA surveillance order for a US person as an agent of a foreign power, you not only need to have a foreign power using the test I just described, but you've got to show that the individual US person knowingly did one of these things: spying, covert action, sabotage or international terrorism, or use of a false identity for the benefit of the foreign power. Or conspiring with someone else is doing those things, or aiding and abetting someone else doing those things. Now, just pause to dwell on this and note a couple of things. It's actually a pretty narrow list. We're basically talking about spies and terrorists and people who are conspiring with or aiding and abetting spies and terrorists on behalf of foreign powers. Contrast that with the list of conditions that make you an agent of a foreign power if you're not a U.S. person. Actually, let me back up before I leave the U.S. persons. Note too, that everything that triggers, the activities that trigger this, they happen also to all constitute criminal activity. The list itself in the statute calls out the idea that the activity is illegal, but even if it didn't, this activity also happens to violate federal criminal law. So in every U.S. person target scenario that you can reasonably think of, the government in theory would have the option of pursuing the criminal law enforcement path instead of the foreign intelligence path. It's different with the non-U.S. persons. We can go broader than that. It covers, oh wait, my slide reminds me, we can't leave the U.S. persons yet because there's a critical caveat. When you're filling out, when you're the FBI agent filling out that verified application and you're laying out your evidence to believe that, say the chef, who's a U.S. citizen in our hypothetical, that he's an agent of the Islamic State as a foreign power and that he's planning sabotage or international terrorism or conspiring with others so to do, you cannot rely solely on his First Amendment protected activity. So if all you could put into your affidavit, into your application, is a description of First Amendment protected speech, things the guy said that did not constitute unprotected speech like incitement to violence, well, the application should be rejected if he's an American citizen. Not so if he's a non-US person. That's a critical constraint. So you need to show he's done things other than just his First Amendment protected speech. Now, for those non-US persons, where you do get to rely on their speech, in addition to the categories we just looked at, spying, covert action, and the like, you can go to a lot more innocuous types of things. Just being an employee, an officer, a member of one of the foreign power entities, that counts. For the subset of foreign powers like Russia or China that engage in hostile intelligence activity against the United States, then even if you don't have formal employment, officer status, or membership status, as long as you're acting on behalf of, in some sense, acting under the direction and control of the group, that's going to count too, even if you are formally not part of the group. And then for good measure, we've added in over time, any individual who's engaging in international WMD proliferation efforts or helping others who are. That's the universe. FISA protects, and it protects here means requires the government to go through the wickets of a judicial review process. FISA protects the privacy of people in a variety of settings in the United States, but authorizes surveillance of those people only when they fall into one of these groups. So the US person target group is relatively narrow and all bound up in ideas of spying and in terrorism. And then the non-US person group is all that, plus just being an agent on behalf of these organizations. It's pretty much what you would expect, of course, though none of that should be too surprising, but let's apply it to our characters here. Let's see, first, why don't we talk about the consul, because he's always the easiest one. Is the consul an agent of a foreign power? Well, we need a foreign power, and we've got one. We've got the Russian government. That's an easy case. In fact, if all we want to do is actually just bug all the phones and put bugs into the rooms of the consulate, we don't even have to do the agent of a foreign power analysis. We can go after the building itself, because that building is the facility belonging to the Russian government. You can always bug the embassies. You can always do that. And if you want to go after the individuals like the consul, well, hey, isn't he an employee, officer, and member, and someone acting on behalf of, for that matter, somebody engaged in, an entity engaged in hostile foreign intelligence activity? The consul's easy. He's supposed to be easy. It's a no-brainer that you can get him as a target for foreign intelligence collection. What about the chef? We talked about him a little bit already. We need a foreign power. We've got one, the Islamic State, international terrorist group. As for his individual aspect, he needs to be either engaged in sabotage or international terrorism or preparation therefore. Our fact pattern suggests that's probably the case. We could probably, if you think about it in terms of criminal charges, you've certainly got the prospect of conspiracy and material support, et cetera, perhaps a violent plot. If you know anything about conspiracy law, you know the violent plot doesn't actually have to be that specified yet, to put it mildly. So he seems a pretty good fit too. Now, if we change the fact pattern though, because in our fact pattern, he really seems to think he's working with the Islamic State. What if what he told his friend who snitched on him to the FBI, what if what he told his friend was that, now I've never spoken to those guys, but I've watched all their videos and I've thought about them. I find them very inspiring. I want to do the sorts of things I know they'd want me to do, even though I have no ties to them. And in fact, I'm planning to bring the fight to New York City just because I'm inspired by them. That gives us a problem.
Yeah, Bobby, is that the so-called lone wolf scenario? Is that, as it's sometimes called? And what happened to the rule that was created for those kinds of cases?
Exactly. This is the lone wolf scenario. It's the paradigm of it. It was created. So at the time of the 9/11 attacks, Zacarias Moussaoui, who for a time was described as the 20th hijacker, he's this guy, he's an Al-Qaeda agent, French citizen of Moroccan descent, I believe. He's in Minnesota trying to learn how to steer planes, steer jumbo jets, but not land them. It just screamed red flag. His case came to the attention of the FBI. There was a process to try to get a FISA order to after he was detained on immigration grounds, they wanted to search his laptop. There was a process put in motion to get FISA approval, and it got hung up because they couldn't specify a particular foreign terrorist group to which he might be for which he might be an agent. The French were able to report to the FBI. The French DGSE said, yeah, we know this guy. He's a jihadi. He's bad news. Don't have him linked to a specific group as such. And that's where it fell apart. In fact, the application process was never even put forward to the Foreign Intelligence Surveillance Court because the expectation was you first had to link him to a particular group. After all, he's got to be an agent of a foreign power, not just a lone wolf. Suffice to say that after 9/11, the FISA statute was changed to create a provision for the lone wolf international terrorism scenario, the Zacarias Moussaoui scenario. And the scenario that I just gave us as a modified version with our chef is exactly that scenario. Bad news, that authority expired due to it had a sunset on it. It had to be renewed by Congress. And along with the handful of other authorities that were from the USA Patriot Act, that provision expired a few months ago, and it is not clear when, if ever, it will be reenacted. Now, to be fair, one of the things that was extraordinary that we learned in the congressional debates and some of the other debates surrounding the idea of renewing or not renewing the lone wolf provision, we learned that it's never been used, which is jaw-dropping if you think about the number of Islamic State and Al-Qaeda independent inspiration scenarios that have unfolded within the United States over time. It's impossible to imagine that they weren't using FISA in any of these cases. So how was it that they never actually needed to use the lone wolf scenario and were able to get a FISA order, presumably in lots of cases nonetheless? And no one knows the answer to that on the outside. I would just submit to you my own speculation that the Justice Department and the FBI and the FISC, hearing their arguments, have accepted really loose and broad theories of what it means to be acting on behalf of these organizations, such that even if you weren't directly in contact with them and weren't actually under their direction and control, but you've sort of volunteered yourself as inspired by them and acting on their behalf without them knowing it, that's close enough. I think that's actually problematic. I think that's what the lone wolf scenario should be used to cover, not some perhaps unduly broad notion of membership. But in any event, that's how it's unfolded. The lone wolf scenario is gone for the moment. Maybe it'll come back.
Yeah,
Maybe.
Bobby, can I then jump in to get your thoughts on what this teaches us about the use of sunset provisions in legislation as a tool here? Because, One of the themes I want to get at in this session and the next one is we've got a statutory framework here to govern us an important set of very powerful government surveillance tools. But as we move along, threats change. Technology changes, the modes of communication change, the modes of methods of intelligence change. So over time, we're going to want to adjust those rules. But statutory adjustment is a hard thing to do. So one tool is that Congress can use is sunset provisions. Say, well, okay, we're going to provide this authority, but it's only going to last for 3 years or 5 years, after which it'll expire unless Congress renews it. Based on what you've seen with the lone wolf provision and others that have expired, what kind of lessons do you draw about sunsets as a legislative tool?
Yeah, I find it so frustrating because I have historically been a proponent of sunsets as a legislative tool. Congress will not. Congress has a lot of motivations. Individual members of Congress have a lot of motivations, and it is, as illustrated, never better than by the 2001 AMF. It's a lot easier in most cases to leave things be, unless you're affirmatively trying to shut them down entirely. But it's pretty hard to tweak on the edges and to alter things on the edges. And so sunsets can create the moments where sort of dead hand control of a prior Congress can force a current Congress to do some tweaking that might be very valuable, can refresh the democratic legitimacy of authorities. But that all makes sense only if Congress will handle things responsibly. And what's happened with the demise of Lone Wolf and other provisions like Section 215 of FISA, which we can talk about later if you want, is that none of them were the main reason for the expiration. In fact, Lone Wolf, nobody was really talking much about it all, except in sort of, insider circles. They all got held hostage to other sort of loosely related provisions that were part of FISA, but didn't have to do with the three that were sunsetting. And so, as I've said on my podcast, the sunset created the occasion to take these provisions hostage. And now the hostages have been shot, and there seems to be no real interest. There's no equally powerful forcing mechanism to force Congress to take the issue up again. It's all gotten bound up in the politics of paranoia about the deep state, that sort of thing. So it's a timely reminder that there's a real cost with sunsets as well, and you got to be reasonably confident that Congress will handle things responsibly if and when you're going to use these. Now, picking up the pace, well, what comes next? We still have the executive. Let me say a few words about her. We need a foreign government entity in the fact pattern to be the foreign power, and we've got Pakistan and the ISI, so we're good there. We need to show that she, who's a U.S. person, is knowingly engaging in one of the limited criminal activities, including spying. I said earlier that we were modifying the hypo to imagine we had at least one source saying that in some way or fashion she's been turned and she's been compromised. Yeah, that kind of gets to the heart of the question for the FISC judges, doesn't it? How good's the evidence of that? Who's making that claim? How persuasive and credible is it? In a moment, we're going to talk about how when push comes to shove, you can write things into the verified application, but does the FISC find that it rises to the level of probable cause? Well, it helps, of course, if you have a real clear basis and a reliable basis for each factual allegation in that application. And that brings us to a topic we call verification, or insiders call the Woods procedures. And this used to be real inside baseball down in the weeds. Now, depending on what Twitter feeds you follow, you might find that it fills up your Twitter feed. It's become a political bone of contention and a really serious policy question. What are the Woods procedures and what is verification? Let me give you the historical context. Just prior to 9/11, there was a FISA controversy. FISC judges had come to learn that they had authorized surveillance of a target based on an application that described probable cause to believe somebody was an agent of a foreign power, where the application neglected to tell the FISC that the particular person had previously been a confidential informant or otherwise had worked with the FBI, which may or may not have changed the outcome if that fact had been disclosed, but it was certainly material. It was relevant. and the FISC was very unhappy that it hadn't been disclosed. And in the set in motion an internal sort of review and reform process under Director Robert Mueller, to think about how are the procedural safeguards that the FBI uses, how could we best align them to ensure that every relevant FBI database has been searched to see if there's any relevant information? How do we ensure that there's backing and that somebody really sort of did the due diligence behind every factual claim and all the background research? This is what then FBI Attorney Michael Woods was set to work to do, and Woods developed a process whereby any facts that go into the application, there ought to be a so-called Woods file, and in the file should be some sort of description of, here's the statement from a witness, here's the evidence that we based that factual allegation on, and also a Woods form that where the agent putting together the application has to check that, yes, I queried this database, yes, I queried that database. It was all to fix these problems and give the Bureau confidence writ large, and therefore give the Justice Department confidence, and therefore give the FISC confidence that once somebody is in there giving an ex parte presentation of an affidavit, by affidavit, of factual allegations, that somebody did due diligence to make sure there was a basis for each fact claim, and that all sorts of other information that ought to be disclosed was in fact disclosed. That's the Woods procedures. That's good stuff. So to sum up, you make a Woods file, and that file should contain the supporting documentation, and it should confirm that any required database searches were done. The case agent signs the form that affirming their personal belief that all the facts are accurate. The Woods file was in fact compiled, that it exists and it was full. The supervising special agent has to affirm this too. And if you've done all that, you're off to the races. Now, notice one thing. The Woods procedures were not originally designed to address all that directly, a very specific sort of problem that's familiar from the context of criminal prosecution. We sometimes call it Brady evidence and Giglio evidence. This is the idea that the government has a powerful and serious affirmative obligation to disclose to the other side exculpatory evidence or evidence that tends to impeach their own witnesses. There's a way of looking at the Woods procedures that maybe it should encompass that sort of thing as well, but it wasn't exactly designed to do that. And as we're going to see when we get to the Horowitz report at the end, and the Carter Page story itself, that turns out to be something that the Woods procedures, at least back then, weren't sufficiently focused on doing, and there ended up being problems under the heading. But before we get to the problems, let's just complete running the traps here. Let's assume we filled out an application for our 3 targets, 3 separate applications. We've got good Woods files supporting them. Who has to sign off on it? It's pretty simple. The field office is generating the application, but it's not going anywhere until it gets approved at the headquarters level in Washington. When that is done, it's not going anywhere until it's approved at the Justice Department National Security Division level. When that gets done, it's got to get approved by the Attorney General himself or herself. And then and only then you can take it to the FISC. What happens there? Well, this is where the probable cause assessment takes place.
And Bobby, can I just jump in before you get to that? Because your last slide raises an important debate, which is many critics of FISA routinely point to the annual stats showing that the government makes, let's say, 2,000 applications for FISA orders per year. And it's rare for more than a few, sometimes 0, to be formally denied. And critics will look at those numbers and say, this shows that the process is basically just a rubber stamp. It's not very constraining. It's not much of a check. Proponents, especially users of the FISA system, say, no. Well, first of all, they might point out that if you look at Title III criminal justice warrants. Most of those are approved too, but they'd say the reason why so many, the overwhelming majority, almost all applications for FISA orders get approved is because of the rigor that goes into the applications, the very high standards procedurally and substantively that are set within the executive branch before an agency can even bring a proposal, a request to the FISC. And so the very high approval rate actually just shows how well the system is functioning. Can you answer that debate for us?
Yeah, so it is definitely commonplace. One of the most common sort of bumper sticker things that people know, who know a little bit about FISA know is that there's the rubber stamp critique. And the stats, there are official stats every year that just seem to scream out on their face that this process is window dressing. Some, basically almost no chance mathematically that the end result is denial. And that seems like a real problem. Indeed, if it is a rubber stamp, then it is a real problem because there's nothing good about having a purely rubber stamp sort of window dressing that makes it seem like there's a judicial check when there's not. Let's look at what Judge Reggie Walton, a federal judge in DC, he gave a detailed account, a rare detailed account of exactly what the sort of process is once the government shows up at the FISC saying, hey, here's an application. And it puts things in a different light, and I'll let listeners and viewers judge what they think of this. The first step is that the application is reviewed by staff attorneys, and frequently that then immediately leads to a back and forth between the National Security Division lawyers who present the application and the staff attorneys over what may be problematic or what needs perhaps further evidence. And so you begin to get this iterative process where FBI may be sent out to gather more information to bolster this application lest it be turned down. Eventually, when that process has settled, the staff attorney makes a written recommendation and assessment to whichever judge has drawn the case. Sometimes the recommendation is that the court, through that judge, should demand more information. Ultimately, the judge does the review. They may or may not call for a hearing. Sometimes these things are real straightforward. For example, our consul, if there's an application to surveil the phone of the Russian consul in New York City, there's not going to be a need for a hearing on that. Or to put a bug in the consulate or in an embassy, there's not a need for a hearing on that. But sometimes there's a call for a hearing. Lots of cases like our chef case or the executive case, those might be hard calls. There's an iterative process, in short, that takes place here as well. Eventually, there is the hearing. Judge Walton says that DOJ sometimes withdraws even at that late stage and at earlier points along the way. And thus that you get any number of situations that should count as rejections but don't show up in the stats. Now, I've never seen reliable stats on purporting to describe how often that happens. Maybe it happens once a year, so it doesn't move the needle much. But it adds a bit of color to the rubber stamp critique. And of course, it's worth pausing here to note that regular warrants also are approved at roughly the same rates. It's not like FISA warrants are approved at some dramatically higher rate than ordinary run-of-the-mill criminal law enforcement warrants. It's just that high approval rate feels less comfortable if you have reason to think that there will be little chance of anything resembling an adversarial suppression motion on the back end. And by the way, now's a good time to mention that even if, as we'll see in a moment, even if there is a prosecution using FISA-derived evidence, and even if there then is a suppression motion, it's not going to be adversarial. It just never is. On paper, it can be, but it never really is. Not in the sense of putting FBI agents on the stand and allowing the defense counsel to cross-examine them. All right. So we're kind of at that point, so let's talk about this. What actually happens once surveillance is approved? Let's assume the FISA court has authorized surveillance of all three of our targets. What happens next with the consul? Actually, sorry, I didn't mean to skip over him. With the consul, of course, the main game is not to prosecute him. There's almost no chance there'd be a prosecution. The game here is to get intel that analysts can use to better understand the intentions and activities of the Russian government. maybe learn about who else they're in touch with, et cetera, all sorts of possibilities, but it's pure intelligence for the most part. The chef's a different story. Yes, a strong traditional intelligence interest. We want to see as much as possible who else he might be working with. What else can we learn about the Islamic State? Might we be able to identify a recruitment and radicalization network by monitoring his communications while taking no action against him? Eventually, though, that's one where you're going to want to prosecute. You're going to want to incapacitate someone who's talking about carrying out a violent act in the United States. So in that case, probably a prosecution. With our executive, well, same as the chef. You're going to want to see what you can learn about the ISI. You're going to want to see if you can learn about other possible compromised individuals, communication networks, et cetera. Lots of intel interests. Maybe not a prosecution interest. It's much less clear in the executive's case. And again, we'd need more fact patterns. We haven't, all we've added at this point is a claim by a human source that she's been compromised. We don't know that she's done anything yet. And then, of course, with her, don't forget, it's a sensitive investigative matter. And so any action taken against her in what we are hypothesizing is an election context against a future potential government official brings with it a host of non-legal issues of incredible sensitivity, as we know from recent years. If there is a prosecution, if there is going to be a prosecution, we're going to have to think about the suppression motion. I feel like I've kind of covered that ground a moment ago, so I'm not going to say anything further except that you can use, the statute allows you to use FISA-derived evidence in a prosecution, but you must notify the defendant that this is FISA-derived evidence. They can move to suppress. In theory, the judge can allow a more conventional suppression motion procedure, but I'm here to tell y'all it never happens. It's always an ex parte in-camera review by the judge of the original FISA application file, and the suppression motion is always denied. It goes down that way every time, and it's a point of real sensitivity for critics of the FISA system. Now back to the analysis track, you've got the fruits of surveillance, but that doesn't do anyone any good if it's not shared with other people. And this brings us to a critical topic called minimization. When those analysts are looking at or they're listening to or reviewing the words that were captured in the surveillance, they may encounter US person information from people other than the target, their friends, their coworkers, their families. So what do you do if there's non-target US person information? Those people have Fourth Amendment rights. They have privacy rights. They're American citizens. Or there may be information about the target that's not evidence of something of a foreign intelligence matter. It may not be crime. It may be entirely innocuous too. What do you do with all this this stuff that's not from the core of what you were trying to get? That's what minimization is all about. Minimization procedures, that's the term of art in this space. And here you see a cover sheet for a publicly disclosed set of minimization procedures. I tell you, these are long, complex, painful to read documents that are all about micromanaging the process of deciding what needs to be just flat out deleted once someone realizes what it is, what needs to be kept, but the identity of US persons in it needs to be masked. That is, instead of saying Matt Waxman, it says US person 1. Instead of saying Bobby Chesney, it says US person 2. And who is allowed to have access to all this stuff to begin with? Minimization is a big deal because the quality of this process and the reliability of this process defines whether and to what extent you can feel comfortable that the FISA system doesn't become sort of the entree into just sort of a giant back door around what would otherwise be ordinary Fourth Amendment protections for US person privacy. Here's how it works in a nutshell. The analyst who sees the raw information initially, they've got to make a finding. Is this in fact foreign intelligence information? Because that's why we conducted the surveillance. If so, no problem. Is it at least, even if it's not foreign intelligence information itself, does it help give us useful context on other things that are foreign intelligence information? That counts too. And then notice this big third category. Even if it's not those things we were looking for, did we, by gathering this information, stumble upon evidence of a crime? If so, you can share it. That's a point of tension for privacy advocates who look at this and think, wait a minute, this only exists to get foreign intelligence information. You shouldn't be able to pass along evidence of crime if it turns out it's unrelated to the foreign intel? Well, the statute takes a different view of that, but it's a major point of criticism to be aware of. So let's assume hypothetically that we're listening in on the executive's home phone, and what we discover is a family member of hers who's on the phone, maybe her spouse, on the phone with another person, a business partner, and they're clearly discussing tax fraud. Can you share with criminal investigators? Yes, you can. And when used in criminal prosecution of the partner or the spouse, well, there can be a suppression motion. But as I told you a moment ago, it's almost certainly not going to work. Okay, what if you have a U.S. person identity like Matt Waxman? The executive's on the phone, it's a foreign intelligence conversation, and they're talking about Matt in some fashion. Well, if it's not relevant to know who he is, you ought to either delete the communication, but we're assuming it's foreign intelligence investigation, so you shouldn't delete it. You should at least mask his identity. In fact, even where the identity is relevant, these agencies typically have policies that by default have you begin, before circulating the analytic report to the customers in the government who need the information, typically you mask the identity of the US persons as an initial matter. Not that they can't ever have that identity, but the customer is going to have to ask for it. And that, of course, leads us to the topic of unmasking, which was in the news and very controversial in recent years. It sometimes gets played up as if it's some nefarious thing to unmask identities. It's an everyday, ordinary occurrence built into the system. The idea is that the customer, who might be the president himself or the national security advisor, would receive an analytic report where instead of naming somebody in a conversation, it says bracket US person 1. Well, we can think of all sorts of reasons why you might need to go back and ask the originating agency to reveal the name of the US person, so you know who is it that, say, the executive in our hypo is describing as willing to work with her to help bring about some state of affairs that would be congenial to the Pakistani case officer that she's talking on the phone with. If she says she has such a person in mind and names them, and the analytic report nonetheless says just US person 1, any reasonable consumer of that information would say, hey, who's US person 1? Is it somebody important, or is it Bobby Chesney? In which case we don't really care that much. Even then we'd still care, but is it somebody who's in a position to do harm to US interests? Assume the consul himself is talking about US person 1 being someone who will help change US foreign policy. Shouldn't our nation's leaders know who is it that the Russians think will work with them? It's an ordinary and uncontroversial result. It should be uncontroversial. You would unmask in that situation. So in the interest of time, let me just kind of skip ahead and skip all past that and just note that this whole framework of Title I stuff has long been described as not actually that controversial. Historically, people treat it as the less interesting part of FISA compared to the stuff we'll do in the next bit of our lecture and after we take a break. Until the Carter Page investigation became headline news, and then the Inspector General of the Justice Department, Michael Horowitz, came out with a report into the original and renewal applications to the FISC to surveil Mr. Page, and found a host of problems with the application, what he characterized as significant inaccuracies and omissions. And the most significant of these were failures to disclose impeachment evidence, especially involving Christopher Steele, but also failure to disclose the FBI's reason to have known, as some of the agents did know, Carter Page had some kind of prior relationship with the CIA that could at least be arguably viewed as relevant to characterizing some of the otherwise very suspicious looking foreign contacts Page had. I'm not sure how exculpatory that information actually really was, but it was certainly material and relevant, should have been disclosed. And the Horowitz report basically documented a systematic failure of the Woods procedures in that particular case, to a pretty stunning degree, given that this was clearly a sensitive investigative matter, or should have been treated as such, and in fact was getting the most senior level attention at the FBI. The omissions were glaring. It was a huge black eye for the FBI. It set in motion a larger investigation, Horowitz went out of his way to say in that original investigative report that he saw no affirmative evidence that any of this was politically motivated. But the errors were real nonetheless, and it raised a question: were these errors that came up in Carter Page's unique case, or was this in fact par for the course? Does it turn out to be that FBI just isn't very diligent about those Woods procedures after all? So the IG is in the midst of a sampling of some 29 case files to check just how good or bad the Woods files look in these other non-controversial cases, or presumptively non-controversial cases. And they found that, in fact, there were lots and lots of problems. Now, DOJ has responded recently, responded by issuing a preliminary response of their own, showing that, yes, there were problems, but the omissions in these cases, at least for the first half of the cases they looked at, were innocuous. They didn't change the outcome. They didn't concern really material facts. There's a lot that's still to come. But I guess I'm telling you all this so that you can know how to perceive what's probably going to be coming in the months ahead, which is more revelations and back and forth, characterizing whether there's a systematic problem that's made possible by the ex parte and camera nature of this process, where the FBI just isn't trying hard enough to put a full and fair presentation of the case in front of the FISC judges, including the stuff that works against their application. I'll close simply by saying that there's more reason to think that they're not as diligent as they should be than I would have thought, and that I did think prior to the Horowitz report. And that was disappointing.
Great. Well, thanks, Bobby. Let's stop on that note